Imagine camping on a gravel bar when an armed, angry landowner shows up demanding that you leave.
Do you want to walk down? It's not that way. That's all my property.
You wouldn't be the first person that this has happened to, and I'll tell you how this worked out for some paddlers on a river local to me here in a moment. Have you ever been kayak camping and wondered, is this a legal spot to set up camp? Is this someone's private property? Do park services have camping regulations here? Is this a designated camping spot? First and foremost, I am not an attorney, nor am I qualified to give you legal advice. I do have extensive experience when it comes to trespassing and matters involving the use of our public lands. While I'm going to focus on Missouri and Arkansas, most states use the same federal waterway navigability laws to model their own state laws after. AmericanWhitewater.org is a fantastic resource and publishes navigability reports for each state on their website. I'll link it in the description along with some other info and resources I'm going to mention in this video. Please check your local regulations and call a conservation or wildlife office if you're confused. Some states have incredibly unforgiving trespassing laws on their riverways, like Texas. In 2013, paddlers on the Meramec River entered onto a gravel bar that had "Keep Out" signs posted. They were confronted by a landowner with a weapon, and there was a dispute about whether or not they had a right to be on the gravel bar that ended in one of the paddlers being shot and killed. The landowner was charged and convicted with murder. Whether or not the paddlers had a right to be on that gravel bar was played out in the trial, and a Supreme Court decision was referenced in making the determination. The Supreme Court had already found in favor of a plaintiff, a paddler and fisherman, that while legally traveling down the river, he was able to stop within the riverbed to fish or camp. So in both cases, courts decided that the paddlers were lawfully present within the stream bed. And in both cases, two conditions were called into question: whether or not the waterway was navigable, and what area made up the stream bed. And these are the two things that you need to know to determine whether or not where you're going to stop or camp is legal. Before going into any more detail about the legality of where you can stop and camp, I just want to say that it's really not worth it to get into any sort of a dispute with a landowner. If somebody does show up disputing that you belong there, it's better to just be agreeable, apologetic, and understanding. Try to move on if you can. If for some reason you're not able to go because it's unsafe due to paddling in the dark, weather conditions, or just fatigue, you can always insist that they go ahead and contact the authorities and say you'll wait for law enforcement response so that you can talk to them. It's not worth having a confrontation put a damper on the enjoyment of your trip or adventure, or definitely not like having an incident like the one that happened on the Meramec. We set up camp extremely early, in part to have those delicious dinners you see in our video, but also so that we have time to leave if we were ever asked to by a landowner. I also encourage you to share this video with any landowners you know that have property abutted to a stream or with a waterway on their property. All right, so we need to address those two issues: navigability and the stream bed. So let's talk about navigability first. There are two kinds of navigability. There's navigable commercially, which is designated for rivers that can convey cargo or passengers on large vessels. These waters and their banks are all public property. And then there's navigable in fact, or sometimes called public non-navigable. Even though they are considered non-navigable for commercial purposes, they can convey small vessels like kayaks or canoes. While the land that the water is on is solely the property of the landowner, the stream or water itself is an easement. This was the case for the paddlers involved in the incident on the Meramec. The gravel bar was considered an easement for fishing, camping, the enjoyment of nature, or to quote the Missouri Supreme Court, shoals and bars which furnish a happy camping ground for the erstwhile fishermen. This is a rather nuanced issue since the ability to float some of these streams can change season to season or year to year. The entire stream itself may not be considered navigable in fact if it's not able to be floated at any given time. In other words, a stream's status as navigable is subject to change. Anything not easy to float on without constant dragging or portaging should be considered 100% private. And no one but the landowner has the right to wade in, fish, camp on, or boat and that property without the permission of the landowner. So now that you know which waterways are navigable or navigable in fact, now you need to know what makes up a stream bed so you can find a place to camp. The most simple solution is to set up camp on an island. If there's running water on either side of it, it's fair game. When determining if a gravel bar or the bank is part of the stream bed, Missouri Conservation offers this guidance. The stream begins at the high water mark. In practical terms, this is where trees and other permanent vegetation begin to grow. So basically, if there's an area where no permanent vegetation like trees exist because it's washed away by the stream year after year, then you're in the stream bed and you can set up camp there. Okay, so let's talk about public lands like national parks. Several of the best rivers in Missouri are in national parks like Ozark Scenic Riverways that make up a huge part of Jack's Fork and the Current River, as well as wild and scenic designated rivers like the 11 Point. These rules are actually really simple. You've got to be at least 50 feet away from a river access or launch. and you have to be at least 1/2 mile away from a designated campground. Now that's 1/2 mile as the crow flies, and not as floating down the river. We almost learned that the hard way. While floating on the current river, we passed the pull-tight campground launch. I used my Garmin watch to determine that we had floated over 3/4 of a mile away from the launch. Figuring we were safe to set up camp, we found the perfect gravel bar, or so we thought. As it turned out, the pull-tight campground was actually only a few hundred feet from the bank of the river through the woods. I mean, I don't have x-ray vision, but definitely consider bringing a map or referencing GPS before making a determination about whether or not a campsite is far enough away from a designated campground. A National Parks worker showed up in our campsite a few hours after we'd already set up camp and told us it was illegal to be there. Once I explained to him how I came to the conclusion that I thought we were good to camp there, he was more or less friendly and said that we could stay. That campsite wound up being raccoon hell anyway because of its proximity to the population of campers at the designated campground. If you know the laws in your state and they're different from the ones that I've talked about here, please start a discussion in the comments so we can help educate paddlers and landowners and make sure that everybody has a safe, legal, and enjoyable time on the river. Remember, adventure.